This podcast discusses child sexual abuse and the impacts of harm on children and families. While we won't include graphic detail, some listeners may find this content distressing. Please take care while listening and consider pausing or seeking support if you need to. There's many and varied support services available, including Lifeline on 13 11 14, Kids Helpline for 5 to 25-year-olds on 1800 55 1800, and the Sexual Assault Helpline on 1800 010 120. If you're outside of Australia, we encourage you to seek a local support service. Jon, welcome to the podcast. I'm so pleased to have you with us. You are a retired Detective Inspector of the Queensland Police Service and an internationally recognised expert in the investigation of child sexual exploitation. Your contribution in this space is remarkable, and on behalf of all Queenslanders and in fact Australians and many people right around the world, thank you for all that you have and continue to do, and I'm really pleased to have you here on the podcast.
Oh, thanks for having me. Listen, it's a privilege. Appreciate it.
So this episode is speaking about what happens when warnings were ignored, and in fact we saw that throughout the case that was reviewed in the In Plain Sight review. Jon, you established and led the Argos Task Force, which is a world-leading unit combating online child sexual abuse and exploitation networks. Talk us through what that was like.
So it's probably important to just clarify that I set up the online capability, the investigative, proactive capability on the internet at Argos. Argos established a couple of years before I joined it to deal with serial and organised child sex offenders in the state of Queensland. I guess it was equal parts purpose and pressure. On one hand, we were building a new capability that could genuinely rescue kids. It could disrupt offenders and result in their arrest both nationally and internationally. But the work just didn't stop. The volume was and continues to be relentless, and the harm that we were dealing with was really confronting and was happening in real time. And I still carry a lot of that with me in retirement. The better that we got at doing the work, the more globalized we became, because we recognized that networks within law enforcement were fundamentally important to stopping abuse globally, because the internet's borderless and we don't know where a child is in one of our investigations until we actually know where the child is. So as that changed, you started working in multiple time zones, which is why I kind of say it never stopped. You're working, you'd start work at 5 or 6 a.m. and you'd catch the end of the US day, and at the end of your day, you're catching the beginning of the European day. So operationally, it was very technical work, but it was also very human, because every image and video, it's not just a digital artifact. It's evidence of a real child being harmed. Those images and videos are crime scenes, and they need to be treated that way. So you carry that with you, and you have to build a team culture that's resilient to that, that's disciplined and really heavily victim focused. Because if you don't do that, the job can really chew you up. And one of the very early things that I did there was, all agencies have accountability to government, to the public that pays for those positions, and so you're measured on metrics, on your key performance indicators. And most law enforcement indicators are on crime clear up, arrests and charges, and that just didn't work for me with kids. So we flipped that on its head and changed the reporting metric to be how many children do we identify and remove from harm this year, as opposed to how many offenders do we arrest and how many charges do we put. I think what I really remember and what I feel has kind of left my shoulders now is responsibility. It's an enormous responsibility. You're responsible for outcomes, for stopping ongoing sexual abuse in its tracks, your team's well-being, for maintaining investigative standards that stand up in court and also stand up morally and ethically. And you very quickly learn that you can't do it alone. The best results come, when law enforcement nationally and internationally, child protection agencies, prosecutors, industry partners are all aligned and moving fast.
I guess that brings me to my next question, really, and that's really about accountability across agencies. So, one of the strongest themes in Part C of the report, which is what this episode is focusing on, it speaks about fragmented accountability across agencies. And we're talking about agencies that are complex, they're multi systems. How do those systems unintentionally create conditions where no one feels fully responsible for a child's safety and, in fact, responds in a way that is productive?
Yeah, look, I guess everyone within that ecosystem has a slice, and every slice of that response has a different rule book and playbook that everybody is reporting to. I guess this report lays it out pretty plainly. Parents and children can be bounced between institutions, police, regulators, and each of those entities has got different roles and different thresholds, different recording systems for action. And the end result is effectively a patchwork where families aren't sure who to call, what will happen, how to be taken seriously. And then you add, I guess, you're referencing the report, the structural issues that Part C is pointing to, which is, lots of forums and task forces, but there's no enduring single governance mechanism with equivalent authority and accountability that's focused purely on child safeguarding. And practically what happens, again, referencing your report, is the butterfly effect. The schemes rely on other schemes to do their part. And if one fails, that risk ripples across the entire system.
Based on what this review has exposed, what are the most important changes systems need to make to ensure that when warning signs appear, children are protected earlier and more decisively?
I think really succinctly, firstly, lowering the operational threshold for protection, not the legal threshold prosecution. So you can take safeguarding action when risk is credible, even if a criminal charge is not yet possible. Secondly, make reporting and escalation simple, safe, and consistent. So if frontline people believe they need proof before reporting, you're already losing time. You're already behind the eight ball. And thirdly, building in an integrated risk function that connects information across agencies and over time. Most failures are not about one missed incident. They're about missed patterns. And it's pretty clear from looking at all of the evidence that's come from this review that this is one of the most crucial parts. In isolation, incidents were either ignored or weren't escalated for a variety of reasons, and then those patterns aren't detected, and that's what needs to happen.
Jon, the report raises concerns about police only being able to act on suspicions of a crime, and that has left children and parents with nowhere to go. As a former police officer, can you explain that to us? You did just speak about thresholds. Is that really what you were talking about in this regard?
Yeah, look, that's certainly a part of it. Like police, and I'm sure that everybody will understand this, that law enforcement work inside a legal framework. To arrest and charge, police need evidence that meets legal thresholds and a reasonable prospect of a conviction. And that is a deliberate safeguard that's built into a democratic system. But safeguarding risk does not always align very neatly with prosecutable evidence, especially with young, and in this case, pre-verbal children, and where we have delayed or completely non-disclosure, and situations that arose where where corroboration is either hard or impossible to obtain. The failure point is when other parts of the system treat a police decision not to prosecute as if it means that there is no risk.
Mm.
It might simply mean that there is not enough admissible evidence today, and that is why child protection and regulatory systems must have their own strong pathways for protective action that do not depend on criminal outcomes. Look, I recall during the process of not the review, but in the lead up to it, I was actually asked a question by a person who I have the utmost respect for within the child protection community about why police didn't seize Ashley Paul Griffith's phone on the day that he was seen to be leaning over the child. And the very easy response to that is, what is the nexus between what he was doing and his phone? And there was no nexus. There was no lawful evidence for police to seize his device. And if they had seized his device and managed to examine it, any evidence on that would then very easily be not allowed into any investigation or prosecution, because there was no nexus to his behavior and his device. If he was seen to be filming the child, yeah, for sure, there's a possibility. But so I had to explain this to this person who I have the utmost respect for, to understand that we just can't do that. Police aren't stormtroopers. They have to act on, they're governed by very strict protocols, and that's how a good criminal justice system should work. So I guess the answer is not police should do more with less evidence. The answer is that police do what police can within the law, and the rest of the safeguarding system has to be built to respond decisively to risk, even when a prosecution isn't yet available.
Queensland has the reportable conduct scheme coming into effect. Do you really see that's playing the role of what you have described just now in terms of joining those pieces, particularly when there isn't that criminal threshold?
Yeah, look, I think this is going to be a crucial part of the solution is joining those systems up. Absolutely, yes.
Just changing tack slightly and talking about offenders themselves and their behaviours, reflecting on your experience in this area, what do parents and workers need to know about people who do abuse children?
I guess they need to know that many offenders are highly ordinary on the surface. They present as helpful, committed, trusted, and they don't look like what the media portray as your stereotypical child sex offender. Like in Queensland, a really good example, I think, that most people would remember is Dennis Ferguson, who was constantly on television as the face of what child sex offenders look like. And that really, it is just not the case. I mean, that's certainly what everybody would like to think that they look like, so you can easily identify them whilst you're walking out in the public. But that is not the case. The vast majority of contact sexual offences against children are actually intrafamilial. That's dad, mum, aunt, uncle, brother, sister, cousin. And it's all about access. So from the family, it then moves on to those that have opportunities to interact with your child, which is neighbours, school teachers, sporting coaches, gymnastics, scouting, life-saving, etc., etc. It's all about access. So I think parents and carers need to also understand that grooming isn't just about the child. Child sex offenders are very adept at grooming adults and institutions. They test boundaries, they normalize small rule breaks, they build credibility, and then exploit gaps in supervision or governance. If an adult feels, if mum, dad, carer, if you feel uneasy but you can't explain why, instinct matters. Trust your gut. And one really critical thing I think that you need to really remember is that if a child does disclose, believe your child. Please, at the first disclosure, believe your child and follow that through.
You mentioned before that you've done a lot of work in the digital space with in the area of child sexual exploitation material being developed and circulated. What's the relationship between child sexual exploitation material and contact offending?
Yeah, there's been lots of arguments about this particular topic for as long as I can remember. And I adopted a very clear standpoint on that particular issue. Child abuse material, child sexual abuse material, is evidence of contact harm. A real child has been abused to create that content. So in practice, I think we see a strong overlap. Some offenders start as consumers and then escalate, and some are contact offenders who also record the content and then distribute. Others, as the internet has evolved, coerce children online into producing material. And that can involve real-time abuse, live streaming, or directed offending. From a law enforcement perspective, we treat online indicators as a definitive marker for contact risk. And one of the things that I always spoke to our team at team meetings about, or when you started working at Argos, was that you should be treating whatever it is that you've received in terms of an investigative referral, whether it's from proactive online engagement or whether it's a cyber tip that's come in from the United States or whatever else, that should be treated as the key to the door, the grounds that gives you your search warrant. And from there, you need to go into the house and treat that person as a contact offender and prove that they're not. You need to work back from the other end. You need to always consider that anybody that is, and you can edit this out if you want to, that any person, and they do, that is child sexual abuse material, either has or has the propensity to hurt a child.
Mm-hmm.
And we need to be working always on the basis that they have hurt a child, and we need to find who they've had contact with, and which children they've abused. There's been so many, the Butner review, there's been so many different academic reviews that have proven that where an offender has been identified for one contact offence, that they are actually responsible for, in many cases, hundreds of offences. And police need to be working from that mindset.
The review includes some pretty shocking stats around child sexual exploitation material. And I think it's an area that parents and carers in the community really need to be far more aware of, and realise that it is happening, it is here.
Yeah, absolutely, it is. I know when I started working at Argos, a lot of the work that we were doing was, referrals that were coming in from overseas, internationally to us. And it wasn't until we did a really large operation in 2004 called Operation Auxin in Australia that we actually really got to see how many Australians have a propensity to hurt children. The content that they were purchasing access to, I think we had, in Queensland, we had about 127 referrals to us, and we arrested around 80 people. The content that they were consuming and paying for access to was produced in Europe. But through the work that we did in that operation, we identified contact offending against, in this case, a number of very young Queensland children. And that was by putting on that victim-centric lens that I just talked about, where we treat them as a contact offender. By examining their hard drives, we found the European content, but we also found evidence of their own offending that they'd captured. So it's not something that happens overseas. It happens in Australia every single day, and there's a large number of what I would call child sexual abuse material survivors in Australia from certainly my early days working in Argos. Their content continues to circle the globe. So we do need to make sure that we have that view that they live, walk, breathe amongst us and work amongst us.
The review really speaks to online child sexual exploitation material as not being a victimless crime. We really need to see that there is a victim at the centre of all of these. Talk to us about how to help get these people justice.
Well, I guess I'd like to weave in what I was just alluding to a moment ago. Look, we know that this harm is ongoing. So for many of these victims, and this will include the victims of Ashley Paul Griffith and others that have been arrested from working in early learning centres. For many of these victims, the trauma is not only what happened to them at the time, it's the knowledge that these images can be traded repeatedly for years without their control. So justice needs to be really victim-centred and practical. That means, from the law enforcement perspective, faster identification, using technology to do that. There's only a very small law enforcement capability in Australia that is dedicated to identification from those images and videos. Stronger disruption and takedowns wherever possible, and investigative approaches that minimise repeated interviews and repeated trauma to the survivors. And it also needs long-term supports that don't exist in this country for these survivors. There's no funding for therapeutic support for CSAM survivors. A court outcome for charging is important, but it's not the end of the harm for many of these victims. So survivors of contact sexual abuse that had that horrendous moment in time captured in a photograph or a video will and do live with it being circulated globally for the rest of their lives. It continues to appear in arrests and briefs of evidence here in Australia and globally, and I recently did some research that proved that. We ran the digital fingerprints of Australian survivors from CSAM cases against recent arrests at Argos, and we detected ongoing trading of their content. But for me, like, one of the things that really resonated when I left law enforcement, and it was kind of an unfinished piece of work that I'm continuing to work on now with the University of New South Wales, is that while we hear from our judiciary that in sentencing of people that have been arrested for possession of child sexual abuse material, we hear the judiciary say that it's not a victimless crime. But our court systems treat it that way because the voices of those survivors aren't heard. The court doesn't hear what the abuse did to their lives, or how the fact that it continues to propagate across the internet feels. We do not have victim impact statements for CSAM cases in this country, and that really needs to change. And that's kind of what largely I'm focusing on at the moment, is making sure that we can get some reform in place where we've identified these people. We know who they were. Many of them were very young children when I started working at Argos. We arrested the offenders, moved the kids from harm, but we still see that content circling the globe internationally. I did research in Canada in May last year that absolutely definitively proved that 3 young boys that were abused up here on the Sunshine Coast in Queensland, their content was seeing 60, 70,000 disseminations up until last year when I did the research. And that's from offending that happened in the early 2000s. But there's no justice for those people. There's no support for those people. There's no voice. Nobody listens to what this did to them. We don't even know where they are now or what's happened to them, and that really needs to happen. So that's going to be kind of what I try to. So we've mentioned I'm retired. I'm retired from law enforcement, but that's certainly what my focus is on the moment, is to try to get justice for survivors of child sexual abuse material.
It was absolutely one of the recommendations and a key finding from the report, in plain sight. So we will be watching along closely and hoping for progress in that space. Jon, thank you so much for joining me on the podcast today. Really, really pleased to hear your insights, and thank you for everything that you do in this space.
You're welcome. Thanks for having me.
That concludes episode 3 of In Plain Sight. In the next episode, episode 4, Systems Under Pressure, we examine how institutional power, culture, and decision-making structures shape whether child safety is acted on or quietly sidelined. I hope you join me then.